Good morning, everybody. So today we will learn about a type of security for performance of obligation. In most cases, the obligation fulfilled voluntarily. However, there are cases where obligations are not fulfilled, so security measures should be taken. There are two types of security, such as holding property and such as pledge mortgage. In civil court, we have no definition, not for fine for violation. If on the basis of agreement is a civil transaction with system of guarantee for performance of obligation, we also talk about deposit. We have a number of measures, formally, presently, and possibility of negotiating all the security measure. Some backup function where there is a breach, an authority function terminate when a guarantee obligation terminates. Example, in 2007, the bank lent money to company X with a guarantee from Mr. John. Mr. John used his land use right as security and gave the bank a land use right certificate. In 2010, the bank company X liquidated the 27th loan contract and lent company X a new loan. The bank and company X agreed to still use Mr. John land use rights as security. Here the question: if company X does not pay and the bank sue Mr. John, does the bank have the right to force Mr. John to perform the guarantee obligation? Second, can Mr. John request the bank to return his land use right certificate to him? We know you have an answer. General provision, guaranteed obligation, type guaranteed obligation. According to Article 293, Section 2 of the Civil Code, secure obligation may comprise current obligation, future obligation, and conditional obligation. For the future obligation, Article 293, Section 3, and Article 294 of the Code will respect a future obligation which is going to arise within a guaranteed time limit. It shall be the secure obligation unless otherwise agreed. Some general provision. Article 294, security for performance of future obligation. With respect to a future obligation, the party may agree on the scope of the secure obligation and a deadline by which the secure obligation must be performed unless otherwise prescribed by law. When the future obligation arises, the parties are not required to reestablish of security for such obligation. We have some scope of guaranteed obligation. This may be part of all of an obligation. Article 293, Section 1 of the Civil Code. An obligation may be fulfilled or partly secured as agreed or as provided by law. If there is no agreement on, or if the law does not provide the scope of security, the obligation, including obligation to pay interest and to compensate for any damage, shall be deemed to be fulfilled secured. If no agreement is reached, obligation include interest, compensation, penalty, but excluding all the money, such as litigation cost. Property used as security. Article 295 of the Civil Code. Condition for asset to be used as security. Not only current asset, but also the future one. Article 108, existing property and upland property. Existing property means property which is formed and to which an entity has established its ownership right and other rights before or at any time of transaction establishment. Off-land property includes non-firm property, firm property that the entity had established his or her ownership after the time of transaction establishment. Ownership of guarantor, except for reservation of title or lien, trading is allowed, general regulation. How to use asset to secure, obligee to hold property as collateral, reservation, or title. The obligor does not hold assets such as pledge deposits, escrow deposit, or property lien. We have some case study. Miss Joe borrowed money from the bank and used her 3 fishing boats as a collateral to borrow money. During the mortgage period, Miss Joe used collateral, the 3 ships boat, to organize a trip to cut up shore cable. In fact, it is an illegal act. The above behavior were detected and handled by authority. Here the question: how to handle 3 ships mentioned above? So we know you have an answer. Relationship between the value of property and secure obligation. The value of property is greater than the value of obligation, pledge or mortgage. Article 307 of Civil Code, deposit, Article 305. Article 307, payment of sum of money obtained from the realization of collateral. The sum of money obtained from realization of collateral after deducting from the cost of realization, capture and realization of collateral shall be paid in order of priority specified in Article 308 of this Code, where the sum of money obtained from the realization of the collateral after deducting from the cost of reservation, seizure, and realization of a collateral is greater than the value of secure obligation. The difference amount must be paid to the securing party. Acceptance of the collateral as a substitution for performance of obligation of the securing party. The securing party may accept the collateral as substitution for performance of obligation of the securing party if agreed by the party. If there is no agreement specified in clause 1 of this article, the secured party may only accept the collateral as substitution for the performance of obligation of the securing party with a written consent of securing party. Where the value of collateral is greater than the value of the secured obligation, the secured party must pay the different amount to the securing party. Where the value of collateral is less than the value of secured obligation, then the unpaid obligation becomes unsecured obligation. The securing party is obliged to follow the procedure for transfer of ownership right to the secured party as prescribed by law. When the property value is less than the value of obligation for pledge mortgage, we have Article 307 unsecured. Where the sum of money obtained from the realization of collateral after deducting from the cost of reservation, seizure, and realization of collateral is less than the value of secured obligation, part of the unpaid obligation are defined as unsecured obligation unless the party otherwise agree additional collateral. The secured party may request the obligor to perform the unpaid secured obligation. Cultivating effect of security measure. Ground for establishing the cultivating force, Article 397 of Civil Code. Security shall take effect against a first party from the time of registration of such security, or the secure party keep on possess the collateral, where the security party take effect against third party. The security party is entitled to reclaim the collateral and payment prescribed in Article 308 of this Code and relevant law. The importance of countervailing force. Article 297 of Civil Code, the right of recourse to the security, such as registered mortgage, but sold by the mortgagor to the third party, the right to priority payment. Article 308, order of priority for payment between the joint security party. When a asset is used to secure the performance of many obligations, payment priority order between the joint security party shall be determined as follows. If all type security take effect against third party, the order of priority for payment shall be determined according to the order of effect against third party. If there are some type of security take effect against third party, while some type of security do not take effect against the third party, the payment obligation with security take effect against the third party shall be given priority. If all type security do not take effect against third party, the order of priority for payment shall be determined according to the order of establishment of type of security. So we have some case study. To take a few minutes to read the case study. An FX company borrows money from BJ Bank and use its asset to as collateral to register with a competent authority. After that, FX borrow money from CG Bank and use the above asset as security with document delivered to CG Bank and also register with a competent authority. Question. If this company does not pay borrow bank, CG company request to handle collateral and were given priority for payment because we're holding document for FX company that were not accepted by BJ Bank. So, can you tell me how handle the above disagreement regarding FX company's loan repayment obligation? All right, so that's all for the case. So we hope that you have some general knowledge about the type of security for performance of obligation. Thank you very much. See you next section.